Oh, thanks for.
Mr. Abico, good morning. You're now live.
Good morning, Judge. I'm trying to figure out where's the audio, the turn up the volume.
Microphone, audio, sound is right here for
Oh,
us.
okay. There we go. Just need to turn up the speakers, Judge. This is Mr. Higgins.
Mr. Higgins, good morning. I'll defer to your attorney for the status of the matter. You're here for an arraignment at this point. Mr. Abico, I'll defer to you before we get started.
Thank you, Judge. I've had an opportunity to discuss Mr. Higgins' case with him and what the facts are. And he understands what an arraignment is, being apprised of his rights and enter not guilty plea and all of that. I believe the parties have reached an agreement. As part of that agreement, Mr. Higgins would like to waive the formal arraignment, formal advisement of rights. He does understand the charge. He's prepared to enter a guilty plea this morning. I prepared it in the nature of an Alford plea because at the time there was alcohol involved and there's an issue of recollection and memory and things of that nature. And so Mr. Higgins wishes to enter an Alford plea. An Alford plea is where, while he may not either recollect or agree that he's guilty of the crime, he's nevertheless, having reviewed the police reports, he understands what the evidence is available to the city. He would agree that were the matter to go to trial, either with a jury or a judge, and the city presented the evidence that it has. And along with that, the defense presented what we might have. He agrees there's a high likelihood that a fact finder or jury or judge would enter a finding of guilt based on the evidence that's presented. Further, he wishes to enter a guilty plea because he wants to take advantage of the city's plea offer, which is at this point credit for time served. I would indicate in the form when I prepared it, I did put in a mental health evaluation, and the city and I had an opportunity to discuss this morning. And I don't believe the city is asking for a mental health evaluation. I believe the consensus is it's more of a chemical dependency issue. And so I believe the city would just be recommending a chemical dependency evaluation, and no new criminal violations. I don't believe the city's asking for a fine, and we're ready to proceed, Judge.
Is your full name Timothy Allen Higgins?
Yes, sir.
Mr. Higgins, you have a right to a formal arraignment. That's to be advised of the charge, the penalties. You're charged with reckless endangerment, which is a gross misdemeanor. The maximum penalty is 364 days in jail and or a $5,000 fine. Your attorney indicates that you're willing to waive a formal arraignment on the charge and enter a plea of guilty to one count of reckless endangerment. Is that correct?
Yes.
Yep.
I'm looking at a computer screen at a statement of defendant on plea of guilty. The plea form tells me that you're 32 years of age. How far did you go in school?
I actually didn't finish high school. I made it to my freshman year, sir.
Any issues at all reading, understanding the English language?
No, just mental health issues. I mean, as far as my career, I've been supervising and managing for the last 5 years. But I have some mental health issues that I do understand I need to be seen for.
We'll get to that down the road here a little bit. Have you gone over the plea form with your attorney?
Yes.
And I am appointing Mr. Haverco to represent you through this matter. And if you had any questions about what it meant to plead guilty, was your question answered?
Yes.
And you realize if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, no witnesses, simply a sentencing, which could be up to the maximum regardless of what's recommended. Do you realize that?
Yes, sir.
With that in mind, as to one count of reckless endangerment alleged to have occurred within the city of Yelm on February 14th, 2022, how do you plead guilty or not guilty?
I plead guilty.
Make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No,
I will find the plea to be freely, knowingly, and voluntarily made. Now, this plea is in the nature of an Alford plea, which means that you're not admitting to any wrongdoing specifically, but you have gone over the police reports and the case with your attorney and realized that if this went to a hearing, that you could get a bad result, and you're pleading to take advantage of the plea bargain. Is that correct?
yes, sir.
I've likewise reviewed the probable cause materials in the case, and I do find there is a sufficient factual basis for the plea. I think, Mr. Haverko, anything further with regard to the recommendation as to sentence?
No, it's as I stated, and I would inquire if there is a no contact order issued on the case. I wanted to address that issue if that's possible.
Okay, go ahead. Yes, there was. I did enter a formal no contact order back on February 14th or shortly thereafter. I'll hear from you on that issue.
Thank you, Judge. Well, he
As long as we can keep physical contact, I know as a no contact order, I'm okay, but like verbally, or
you want
telephonically.
to be able to have verbal and telephone.
Yeah, that way for bills, and we have to re-sign our lease this month for the house that they're living in, and
Okay.
certain matters.
Do you have a place to stay?
I do have another place that I'm gonna be staying. I don't have the address to it right now.
Okay. Well, he advises that he would like the order modified to allow for written and verbal contact, if not in person, by telephone or through a third party. He does have another place that he can stay. I would say he's contrite today about what happened, and he thinks his insight into it is it's kind of a combination of some mental health issues, which he does realize he needs to address. And in the police report, it indicates there was a use of meth. I don't know. I don't have any way of knowing if that's accurate. He says that's not accurate, but he was just simply drinking a lot. I mean, either way, obviously it led to the issue that it did. But apparently there's might be some paperwork, leases, documents, things that need to be signed, and there needs to be, he would like to, he feels there's going to be a need to have some kind of ability to have some kind of communication to, again, in order to deal with some business housing. Yeah, and so I think all he really wants is to be able to have telephonic contact.
Mr. Deli, on behalf of the city sentencing recommendation.
The sentencing recommendation is a joint recommendation. I think with regard to the no contact order, I think there's a Superior Court no contact order in place, of which he's been charged with 2 counts of violating thus far, and understand he's not going to be released today. But I'll leave it up to your honor if you want to impose our own.
Yeah, then I'll be sent for that.
There's no contact under his current order.
I'm inclined to leave that. I understand Mrs. Higgins is in the courtroom. Ma'am, is there anything you wish the court to know before I impose sentence in this matter? If you would step up to, there's a microphone that so you can step up to there.
I found out that the lease is not up until June or July, because I have the profile on my phone and it says it's not up this month. It's not up until June or July of this year.
That'll still,
You still got a couple months.
that'll still,
Anything else you'd like me to know?
I don't know if I'm supposed to address her or not. Just tell me.
I also got tax papers that I gotta have him sign because I already filed our joint taxes. I didn't know how to go about doing that either because I need him to sign them.
You have telephonic communication. She can email those to me and I can sign those. Send them back without having to have any physical contact.
Mr. Higgins, you have what they call a right of elocution. You can tell me anything you wish. You don't have to say anything, but if there's anything you think I should know or want to tell me, now is the time.
He's speaking to me here.
To you.
I was just talking to the attorney here, as far as the taxes and the lease go, the lease will be up still before the no contact order is out of place. And that's why I'm asking for telephonic communication so that it can be emailed to me, signed, and emailed back to her, as well as the taxes could be taken care of the same way without any physical contact, if that's what she wishes.
I'm fine with that, if that's what we gotta do to get this stuff done, because I also need a little bit of help trying to get everything paid in.
Financially, I'd be able to help her out too, as soon as I can get out of here and resume working. That's all, Your Honor.
Mr. Higgins, here's what I'm going to do. I won't post 364 days in jail. I'm going to give you credit for 17 days served. And that leaves 347 days, which is suspended on a number of conditions. One is going to be no law-abiding behavior. And the next one is going to be obtain a drug and alcohol evaluation and comply with any recommended treatment. I think that's very part of the issue here. Is the city asking for a mental health evaluation? There's maybe some kind of a codependence.
Yeah, I'm not going to object if you order it, Your Honor.
I think I'm going to defer to the Superior Court on that. You're not to possess any firearms, and you're not to consume any non-prescribed drugs. And that would include marijuana and be in possession of any drug paraphernalia. Is the city asking for any fine?
No, Your Honor, I think that's just probably adds stress to the situation.
And I think given the behavior that led to Mr. Higgins' incarceration, that was fairly disturbing. And any lawyer, including Mr. Haverco and Mr. Hill, has seen situations where things like situations like that resulted in serious injury and occasionally death. I'm not inclined to modify or release the no contact order at this time. I'm satisfied that the parties, it's a long time between now and April 15th. Any tax statements that need to be assigned, that can be done through lawyers. And I'm sure that Mr. Higgins will have a public defender assigned to him in Superior Court. Mr. Higgins, you'll be released on our hold today, lifting bail. However, it's my understanding that you're likewise being held on a county hold with regard to new charges. And I can't speak for them. I don't know how that's going to work out. But as far as we're concerned, the 347 days are suspended on the condition that you comply with the conditions of the sentence. Most important to me at this point is no further domestic violence, no further criminal law violations, and to ensure that we need, I think, a mental health evaluation, which I'm sure the county's going to ask for, and at least a drug and alcohol evaluation and compliance with any recommended treatment. It's my experience that the evaluation may recommend a mental health evaluation, and if that's it, so be it. Any questions?
No, sir.
Takes a moment to electronically sign a statement. Reviewing the judgment and sentence, I'd ask the attorneys to do the same and sign where indicated. Mr. Higgins, I'm going to wish you the best of luck. It's my feeling, based upon the information I have regarding the situation that occurred and regarding yourself, that if you address some mental health concerns, if you address a substance abuse issue, which more often than not is self-medication for issues that should be dealt with in other ways. Once you take care of that, I'm convinced. If you successfully take care of that, the criminal justice system is not going to see you again. I'm going to wish you the best of luck, okay?
Thank you, sir.
Take care of yourself.
Okay, free to go.
Thank you.
I guess.
I gotta wait for him.
There we go. Takes me.
Taking care of me.
Okay. No.
Did you need anything else?
No.
Mrs. Higgins, that concludes the matter. I'm going to wish you the best of luck. I realize these are kind of troubling times for you, but I know that Mrs. Higgins if you want to go and get a copy of the no contact order, we do have a victim advocate, and you can get the contact information with her at the window. Good luck to you, okay?
All right.
You take care.
Morning, Judge.
Mr. Abaco, ready for the next matter?
I am, Judge. This is Bo Devon Frost.
Mr. Frost, good morning. How are you?
Morning.
I'm okay. The matter comes on for an arraignment on a theft matter. I have had an opportunity to discuss the matter with Mr. Frost, and that the case today is scheduled for an arraignment. I've explained to him what an arraignment is. to be apprised of the charges, to be apprised of his rights. He understands those. He would like to waive formal arraignment so as to enter a guilty plea. I have gone over a statement of defendant on plea of guilty with Mr. Frost, and he wishes to enter plea because my understanding, the city is likely, well, not likely, the city is going to be recommending a time served recommendation, and Mr. Frost would simply like to dispose of that case today and proceed with plea and sentencing.
Mr. Frost, do you disagree with anything your attorney just said?
No, not at all.
I'm looking at a statement of defendant on plea of guilty to one count of theft in the third degree alleged to have occurred within the city of Yelm on May 1st of 2021. Have you gone over the plea form with your attorney?
Yes.
And if you had any questions, were your questions answered?
Yes.
Any issues at all reading, understanding the plea form?
No, huh?
Accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 364 days in jail and or a $5,000 fine. You realize that?
Yes.
With that in mind, as to one count of theft in the third degree, alleged to have occurred within Yelm on May 1st, 2021, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No, huh?
I will find the plea to be freely, knowingly, and voluntarily made, and your statement of paragraph 11 does satisfy the factual elements of the offense. The recommended sentence is all jail time suspended on the condition you stay out of trouble, have law-abiding behavior. Mr. Haverco, anything in addition to that?
Nothing, Your Honor. It's just, for the next year, no criminal law violations. The city, given his in custody status, the city wasn't asking for a fine.
Bill, anything to add?
Nothing, Your Honor.
Mr. Frost, anything you'd like to tell me?
Nothing.
Again, what I'm going to tell you is I don't like to leave people in jail, but after the multiple non-appearances, after promising to report, I felt I didn't have any choice but to have you held on low bail. Sorry I had to do that, but I felt it was necessary. I am going to follow the recommendation. 364 days in jail, credit for 4 days served, 360 suspended on the condition you have law-abiding behavior. Given your financial situation, no fine is going to be imposed. But you do have significant jail time hanging over your head, and whether that's reimposed or not is up to one person. I'm looking at it right now. Any questions?
No one.
Mr. Frost, unless there's some other hold on you, you'll be released on this charge today. Good luck.
Thank you.
Thank you, Judge.
Trevor, thank you.
I'm not sure. Can't just have a seat on the.
And it looks like the last one on the in-custody calendar has bailed out.
That was from a previous.
Oh, that was a okay. Then he still is. He was still there. Okay. Man, yeah, I keep getting that pop-up window. Will close without it, and I have to mess with it.
Good afternoon, or sorry, Judge. Good morning, Judge. So this is Julian Daniel Jennings.
Good morning, Mr. Jennings.
Good morning, Your Honor.
His case comes on for an arraignment this morning on the charges of criminal trespass, first degree, and resisting arrest. I've had an opportunity to meet with him and discuss his case with him and discuss what an arraignment is, to be apprised of his charges, what they are, the elements, his rights. He'd like to enter a guilty plea this morning, and I explained that we can do that if he is willing to waive formal arraignment. Again, though, I did review with him what the charges are and what his rights are pursuant to an arraignment. We're proposing to enter straight pleas of guilty to, on count one, the amended charge of criminal trespass in the second degree, reduced from criminal trespass in the first degree. And actually, in having read the report, it doesn't really matter, but I'm not sure why he was charged for first degree anyway, because he was in the parking lot. But anyway, it's by agreement. So it'd be the amended charge of criminal trespass in the first degree, and then count two, resisting arrest. And the recommendation just would be suspended jail time on both, 90 days on each. Suspended would ask that they just be run concurrent. Of course, it's all suspended anyway. I don't believe the city was asking for a fine. It would just be credit for time served, and then that would be it. And I've gone over with him what the statement of defendant is on plea of guilty with him, and he understands what that is and the rights that he gives up. And so ask Your Honor to inquire.
Is your full name Julian Daniel Jennings?
Yes, sir.
Jennings, you disagree with anything at all Mr. Havercook just said?
No, sir.
It's my understanding you're willing to waive arraignment and enter pleas of guilty to one count of criminal trespass, second degree, and one count of resisting arrest. Is that correct?
Correct, sir.
I'm looking at a statement of defendant on plea of guilty to those charges. Tells me you're 33 years of age. Any problem reading, understanding the English language?
No, sir.
Have you gone over the plea form with your attorney?
Yes, sir.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. It'll simply be a sentencing, and that could be up to the maximum, which would be a 90 days and or $1,000 fine on each charge. You realize that?
Yes, Your Honor.
With that in mind, as to one count of criminal trespass in the second degree and one count of resisting arrest alleged to have occurred within the city of Yelm on March 20th of 2021, how do you plead guilty or not guilty?
Guilty.
You make those pleas of your own free will.
Yes, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find your plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. The city have anything further with regard to sentencing?
No, Your Honor, it's joint recommendation.
Mr. Haverco, anything further with regard to sentencing?
Nothing to add, Your Honor.
Mr. Jennings, you have a right to tell me anything you think I should know.
No, sir.
I indicated to you when we spoke on the telephone that yesterday that the last thing I'd like to do is hold people in jail, but I figured it was just one day. And with the number of non-appearances before, I didn't feel I had any choice but to ensure your appearance by keeping you in on the low bail. I am going to follow the recommendation. I'm not going to propose any fine, but 90 days on each charge. Give you credit for 1 day served, 89 suspended on the condition you have law-abiding behavior. That would include don't trespass any place where you're not wanted.
Yes, sir.
Now, you're going to be released on this charge unless you have some other hold on you from some other jurisdiction. You'll be on your way before too long. I'm going to wish you the best of luck. You take care of yourself. Any questions?
You as well, sir. No doubt. No.
Good luck to you.
Thank you, Your Honor.
Haverco, thank you. I guess we'll see you in a few moments.
Yes, sir. minutes.
Started doing it once. I was getting 3-4 times before I could. Doesn't have a little orange bar like it usually have on the judgment and sentences. Doesn't make any difference. Yeah, usually you have drive space. You have that.
Yeah.
But for some reason,
They said it was for edits, but that's the edit.
well, okay. With that, let's revert to the 8:15. Brendan Goss. Take that matter now. Call the matter of Yelm versus Brendan Goss. Mr. Goss, you're muted. Could you unmute yourself and let me know if you can hear me or not?
I'm okay.
Good morning. How are you?
All right. I'm sick. That's why I didn't come in person like I normally do.
Is this Brendan T. Goss?
Yeah.
Mr. Goss, the docket indicates to me that we have perhaps a problem with treatment. What's going on there?
Oh well, I just got back from my grandfather's funeral, and then I just got my health insurance back. And everywhere I call to do my treatment, they just don't accept my health insurance, or they won't allow me to do it there unless I do my assessment there. And then, where I did my assessment, they don't accept my health insurance, but I paid for the assessment in cash. So I've been looking and trying. I just can't find nowhere to do it.
Any, what do you plan on doing? I realize that, yeah, financing, health insurance, et cetera, that's always an issue in these things. But what, going forward, what are you gonna do?
I've been talking to my father about just doing an inpatient program instead of outpatient program,
Uh-huh.
and he thinks that's a good idea.
Yeah, the recommendation is a 3-month program.
Yeah. So it's 3 months of once a week and 3 months of once a month with urine analysis testing.
So do anything from the city with regard to Mr. Goss? We have a recommendation. Apparently, a financial issue has reared its head.
Well, it's been going on since 20. So we're now 3 years, no, 2 years and 362 days from the first offense. "30 days.
Mr. Goss, did you hear that?
Yeah.
The city's recommending that I reimpose 30 days incarceration based on failure to comply with the judgment and sentence entered. What's your response to that?
I would prefer not to do any time because I don't feel like I should be punished for trying.
You know, I don't want to see you serve any time either, but I don't want to see you reoffend and be back in court
Well,
or elsewhere on similar charges.
I ain't going, like, unless you send me back to jail, I ain't going back to jail. It's been almost 2 years since I even talked to a cop. I have no intent of going that way. Like, as soon as I'm done with court, I'm leaving Washington. Like, I'm going down south to work.
Are you willing to do the program recommended or get another evaluation?
Yeah. After I was done being sick, I was gonna continue again, continue looking for treatment, or I was gonna call the place where I did my assessment and see if I can work out a payment plan instead of just doing health insurance.
The one thing, if you don't feel the recommendation is a fair one and needed, you can always get a second opinion as,
Yeah, that's what we did. I got that first one, and they wanted me to do intensive outpatient, which I really could not afford. And then that was like for a year or two of doing treatment, and then I went again, and they recommended 3 months of once a week, no, once a week, and 3 months of once a month with ear analysis.
okay, this is what I think I prefer to do. Jail time is, to me, an absolute last resort. It doesn't do any good except to keep people off the street and out of trouble and not pose a public safety risk of any kind. What I'm going to do is I'm going to schedule you for a review 6 weeks from now, and we'll see how you do then. I want you to either get a second evaluation, begin treatment on the first one, working something out, but do something. Do something.
Yes, sir.
And if not, the city's recommending 30 days, and could be less, could be more. Is that going to work?
Yes, sir.
I would really like you to get the evaluation, get any treatment that they feel is needed. Hopefully, given the lapse of time, like you indicated, hopefully a new evaluation would indicate that maybe a class or two is necessary instead of a lengthy treatment.
Yeah.
That's not my area. That's up to the evaluator. April 14th at 8:15 is going to be your next court date, Mr. Goss. Stay out of trouble, yes, and it does speak well for you that the lack of any issues in the meantime, and that's what I look at most closely. Any questions?
No, sir.
We'll send you a copy of today's order. In the meantime, you take care of yourself, okay?
Yeah, you too.
Closed. Mr. Lunderville, you just unmuted yourself. Are you able to hear me?
Yes, Your Honor.
You were on an SOC with regard to a neg 1 charge, which took place on December 26th of 2020. As for review, it looks like there may be a concern that you violated the stipulated order of continuance by getting a new DUI and a reckless driving charge up in Pierce County.
Yes, Your Honor.
It looks like you entered a plea of guilty to one charge of reckless driving, and that leaves us here. Mr. Dilly, any?
Let's see, just move to revoke the SOC.
Mr. Lunderville, the the city has moved to revoke the SOC, and that would involve entering a plea of guilty to the original charge of neg 1. That's what I'm inclined to do, unless I hear differently from you. If you admit that you violated the terms of the SOC, I'll do that.
I did.
That would result in a finding of guilt. I wouldn't add any monetary penalty or anything. It would simply convert the matter to a conviction. What's your position?
I am guilty of that, Your Honor.
We'll do that then. I'm simply going to enter a finding of guilt to 1 count of negligent driving in the 1st degree. Are you doing anything about the situation?
Yeah, I've been in treatment for 2 months now with full compliance. So I'm in the intensive outpatient over in Yelm in a treatment program.
I'm glad to hear that. I've known too many situations where somebody got behind the wheel of a car when they shouldn't have, and they wound up killing somebody, putting themselves in the hospital. Bad things happen.
Absolutely, Your Honor. It's selfish.
I'm glad to hear you're doing something about that. Because yeah, if you know, if you don't get a problem, the problem gets you. We all find that out in our lives.
That's right, Your Honor.
I'm not going to impose or suspend any jail time. I'm going to leave that up to Pierce County. I'm simply going to convert the SOC to a conviction, and that'll close the case.
Okay.
I'm going to wish you the best of luck. And again, I'm urging you to stick with the treatment. 1, it sounds like it's court mandated, but 2, for your own sake, stay out of courtrooms, stay out of jails, stay out of hospitals and morgues too.
Yep, definitely.
Okay, Mr. Lunderville, that concludes the case. With that, I'm closing the file.
Okay, thank you, Your Honor.
Thank you, sir. You take care.
You too.
Let's see, this form doesn't really, I'm looking at that, it looks like do we need to add anything to this form? Turns into, ready to sign then? Got it. Need that closed without problem. And present, I have Mr. Gordon. Now we're going to move to the 9 o'clock calendar. I'm going to call the matter of Yelm versus Kurt Borden. Mr. Borden, good morning. How are you? Mr. Carroll, I see you there as well. We'll address your matter at this time. Set for a pre-trial. I'll turn to the city for the status of the case.
I believe I think there's going to be a continuance in this one, Your Honor.
Your Honor, good morning. That is correct. For the record, Dan Garrell on behalf of Kurt Borden. Your Honor, this is the first pretrial, I believe, perhaps the second. Mr. Borden has been represented by my firm since his arraignment. However, I am now the attorney of record on the matter and am requesting a continuance for further investigation and negotiation.
And that would be to March 31st, it looks like is the request.
That is correct, Your Honor.
Is that going to work for yourself and Mr. Borden?
Works for me, I believe. Mr. Borden works for him as
Yes,
well.
Your Honor.
Mr. Borden, we're going to reset your matter to to the 31st of this month. Stay in touch with your attorney, and any conditions earlier imposed remain in effect. Any questions at all?
No, sir.
Good luck to you. We'll talk to you and Mr. Girl at the end of the month. Take care and have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
We'll send you today's order resetting the matter. Well, the matter of Yelm versus Jesus Shippers Lopez, we'll address that matter now. I'll turn to the parties for the status of the matter.
Good morning, Your Honor. Philip Pierce on behalf of Mr. Chippers Lopez, who's present on Zoom, and no objection to proceeding in this manner. And Your Honor, the city and I believe have reached a resolution on this matter. We're asking the court allow entry into a stipulated order of continuance. Yesterday, Mr. Chippers Lopez and I had a chance to prepare that document. He was sent a copy. We reviewed it together, answered all of his questions. I believe he understands what his obligations are. Thank you.
Mr. Dilly?
It's all agreed, Your Honor. And then just follow up on the disposition of the infractions. Part of the agreement would be to dismiss those.
Okay. Mr. Shippers Lopez, good morning to you. For the record, your name is Jesus Shippers Lopez.
Yes, Your Honor. Good morning.
I'm looking at a stipulated order of continuance. Have you gone over that document with your attorney?
Yes, Your Honor.
If you had any questions, did your attorney answer them?
Yes, he did, Your Honor.
Your attorney has negotiated an agreement with the city under the terms of which the matter is going to be continued for a period of 2 months, or 2 years, excuse me, under a number of conditions. Those conditions would include no criminal law violations, don't drive unless licensed and insured, and no drinking and driving, and no alcohol-related infractions even. If anybody asks you to take a breathalyzer, you're to do so, and don't use or possess alcohol or non-prescribed drugs. And keep in touch with us if there's any change in address, and notify your attorney and ourselves. Now, at the end of the 2 years, if the conditions are abided by, the result of the matter will result in I'm struggling with a new form here.
An amendment to negligent driving first degree, Your Honor.
I'll help. Thank you for the help. Mr. Shippers Lopez, you have a chance to kind of minimize the damages here. Your attorney's put you in that position. It's up to you whether you do that or not. Now, as you know, if you violate the agreement and the city proves that, we're back to square one, and we'll simply have a hearing based on the police reports, and you know what the result of that would be. You have a chance to minimize the damage here, and it's up to you whether you do that or not. It looks like there's a probation fee of $550, which can be paid at the rate of $25 a month beginning April 3rd. And we're going to ask that you contact the city's probation monitor within a reasonable period of time. Her contact number is on the agreement. Any question at all?
No, Your Honor.
I'm going to wish you the best of luck. You take care of yourself. And once again, the penalties for drinking and driving are such that they're the way they are because of the number of people we kill every year. And they're talking about reducing the breathalyzer number as we speak. I'm going to wish you the best of luck, and hopefully this is a situation you've learned from, and one that will not be repeated. Take care of yourself.
Thank you, Your Honor. You too.
Thank you. We'll be sending both you and your attorney and Mr. Shippers Lopez a copy of today's agreement. Good luck.
Thank you very much, Your Honor. Have a good day.
You as well. And I will cite for the record, because I didn't earlier, the two infractions, headlamps and NDOL are dismissed. Let's call the matter of Yelm versus Misty Lazar. I see Ms. Lazar is present but muted, along with Mr. Nerlach, your attorney. Good morning.
Good morning, Your Honor.
That are set for the pretrial. I'll defer to the parties for the status of the case.
Thank you very much, Your Honor. And so Mr. Dilly and I have had a couple of conversations about this. We're just trying to track down some treatment records for Ms. Lazar. She did some pretty extensive inpatients. We're just waiting on those to come into my office. I think that we're really close to a disposition. This is our first pretrial, but we're just asking to reset this. And I believe a waiver and continuance has been uploaded to O Court.
And I've signed that, Your Honor.
It looks like the request is reset the matter to April 14th. That's what we'll do.
That's correct.
At the request of your attorney, we're resetting your case to April 14th to allow further discussions and discovery in the matter. In the meantime, stay in touch with your attorney, and any conditions of release earlier set remain in effect. Any questions at all?
No, Your Honor. Thank you.
Today's hearing, we'll send you a copy of today's order, and we'll talk to you middle of April. Good luck.
Thank you.
Thank you, Your Honor.
Present by way of Zoom is Nina Sanchez. We have, looks like Mr. English.
No, it's okay. Hello?
Good morning, Ms. Sanchez. Your attorney is now appearing, and he'll unmute himself in a moment, and we'll proceed to hear your matter. Mr. English, good morning.
Good morning, Your Honor.
It looks like we have two matters on the calendar. One is an assault 4 DV charge going back to September 28th. Except for pretrial, it looks like there's an arraignment scheduled on a new charge. Is that wish to proceed?
That is my understanding, Your Honor, and we're ready to proceed on both. If we could begin first with the 2021 case, cause number ending in 397.
That's a matter set for a pretrial. I'm looking at the screen. It looks like there is prepared and is before me an SOC, a stipulated order of continuance. Mr. English, I'll defer to you to address the matter.
Thank you, Your Honor. I spoke with the city regarding this case, and they are willing to extend my client a 24-month stipulated order of continuance, which is premised on my client getting a DV assessment and not committing any law violations for the 24-month period. I went ahead and explained what all of my client's obligations are to her last night, along with all of her trial rights that she'll be waiving as a result. And I do believe that she is making a knowing, voluntary, and intelligent decision to enter the agreement. Thank you.
Billy, anything to add?
Nothing to add, Your Honor.
Ms. Sanchez, do you disagree at all with anything your attorney just said? You're muted. Could you unmute yourself so we?
No,
can-
sir.
Hey, thank you. Thank you very much. Have you gone over the agreement with your attorney?
Yes, sir.
And if you had any questions at all about what it meant to enter into this agreement, was your question answered?
My questions were answered, sir.
Under the terms of the agreement, this charge can be dismissed 2 years from now if you comply with certain conditions. Law-abiding behavior, of course, and most important to me is do a domestic violence assessment and comply with any recommended treatment.
Okay, sir.
If you do that and pay a probation fee in the amount of $250, that's the least important thing to me. The charge will be dismissed. It will not go on your record as any sort of conviction.
Okay, sir.
Now, on the other hand, if you violate the agreement and the city proves that, you've given up your right to go to trial, all of your trial rights in order to get this agreement. We would have a hearing simply based on the police reports, and you know what the result of that would be, and that would subject you to the possibility of significant jail time. You realize that?
Yes, sir.
I approve of the agreement, of course, and I'm going to wish you the best of luck. We'll expect the domestic violence evaluation within the next, say, 90 days. Is that going to work?
Yes, sir.
Good luck to you. You take care of yourself and stay in touch with your attorney. And if your address changes, make sure that we know about that.
And then we have next matter.
We also.
And my apologies, Your Honor. Before we move on to the new case, can I confirm that at the end of the 24-month period, if she's in full compliance, if her presence is waived for the final review?
As far as I'm concerned, it is.
Yes.
And the city.
Okay.
Well.
Okay, great.
Sanchez, it's always a good idea to check with your attorney to make sure everything is in order at about the time 2 years expires. Okay. I am now looking at a citation to the alleges that honor about September 28, 2021. Make sure I'm looking at the right file here. That honor about February 26 of 2022, you committed the offense of assault in the 4th degree DV. The charges of gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. With that in mind, I'm going to turn to your attorney for the entry of a plea.
Thank you, Your Honor. I didn't review the complaint with my client because we do not have a copy, but I did advise her of what the charge is from GIS, and will waive formal reading of the complaint, waive further advisement of rights, and enter a plea of not guilty. Thank you.
Ms. Sanchez, a plea of not guilty has been entered on your behalf. That preserves your rights. We will now set the matter for a pre-trial conference, give you a chance to discuss the case with your attorney, and him, of course, a chance to obtain what he needs to obtain and review the matter.
And I would just like to put on the record that I'm appearing as a courtesy for this particular matter.
Hey, Mr. English, thank you very much. Do you expect a written notice of appearance or? I still have you. I still have you. I can't seem to. You're still editing the SOC. Shoot. I can't get out of the SOC. I have you still editing.
Yeah, you'll have to close it because I'm not.
Mr. English, I'm experiencing computer issues here. Yelm Court's, in my opinion, leaves a little bit to be desired. I've now signed the SOC. Now we need to set the second case for a pretrial. Mr. English, are you going to be representing Ms. Sanchez on that, or do we know yet?
We don't know yet, Your Honor.
Ms. Sanchez, I'm going to set you for a tentative pretrial representing yourself. The public defender will be present and available if it comes to that. But until that happens, we're simply going to give you a court date. Sanchez, your next court date will be March 31st at 11 o'clock in the morning. It is set for a pretrial. Now we set it so that a public defender will be here to represent you if it comes to that, but that remains up in the air. If Mr. English is going to represent you, I believe he'll probably give us a call and reschedule the matter to an attorney.
And we'll be sure to do that if need be. Thank you.
Mr. Sanchez, I'm going to wish you the best of luck. You take care of that yourself. That concludes today's hearings. Good luck to you. We'll talk to you at the end of the month.
Thank you, sir.
Thank you, Your Honor.
Thank you.
Good morning, Your Honor.
Oh, good morning. How are you?
I'm fine, thank you. I'm here in the matter of Yelm versus Isabella Wilmoth, and I spoke with her this morning. I think she should be here via Zoom.
We're now waiting for her to sign in.
Okay, great.
And Your Honor, we do have a resolution in this matter, and I'll let Mr. Crow go through that.
Ms. Wilmoth, I see you are here now, but you're muted. If you'd unmute yourself, we're going to address your matter at this time. Good morning. Hey,
good morning.
Your Honor, Mr. Dilley is correct. We do have a resolution in this case. There are 3 charges. Mr. Dilley has agreed to dismiss the malicious mischief charge and dismiss the assault in the 4th charge, leaving us with a minor in possession. The recommendation for the minor in possession is all jail time suspended and the fine suspended. I didn't have a specific, at least not a significant conversation with Mr. Dilley about that, but I put in there $150 in fines, knowing that he and I may have to have a discussion about that. However, this is suspended for 12 months, and that's a recommendation. I did have a chance to go over the plea of guilty with Ms. Wilmoth this morning, but I wasn't able to use O-Courts to get her to sign it. For some reason, O-Courts refuses to work at all on my computer, but it does work on my paralegal's computer, magically. So we had some issues there. So I have signed it. I don't believe she has, but I did talk to her about the rights that she's giving up by pleading guilty to this one charge, including the right to the trial, the right to confront witnesses who were brought against her, the right to appeal, the right to testify on her behalf, or the right to remain silent. In addition, she knows that this is a gross misdemeanor. The court has the authority to sentence her up to the maximum sentence, which is 1 year or 364 days and $5,000. But knowing that that's not the recommendation of the court, I believe that she's making this plea willingly, and that nobody has placed any pressure on her or done anything to force her to sign on the guilty plea. And with that, I'll leave it to Mr. Dilly if he has anything to say, and then to the court.
Nothing further, Your Honor. It's a great recommendation.
Ms. Wilmot, for the record, is your full name Isabella Wilmot?
Yes, it is.
I'm looking at a statement of defendant on plea of guilty to one count of being a minor in possession. Plea form tells me you're 19 years of age. You have discussed the plea process with your attorney by telephone, I trust.
Yeah.
If you had any question about what it meant to enter a plea of guilty to a criminal charge, did Mr. Crowe answer your question?
Yes, he did.
I accept the plea, you give up the rights specified in the plea form, no trial, no appeal, no witnesses. It's simply a sentencing which could be up to 1 day short of a year in jail and a $5,000 fine. You realize that?
Yes, I do.
With that in mind, it's one count of being a minor in possession of alcohol within the city of Yelm on October 31st, 2021. How do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
And on October 31st, the date of alleged violation, you did possess liquor as a minor within the city of Yelm. Is that correct?
Yeah, that is correct.
I will find the plea to be freely, knowingly, and voluntarily made. And this statement of the defendant does satisfy the factual elements of the offense. With regard to sentencing, I believe I have the city's recommendation. Mr. Crowe, anything to add?
Nothing to add other than that this is a first offense, and I would just ask the court to follow the recommendation. It's a good recommendation.
Okay. Ms. Wilmot, anything you'd like me to know or you'd like to tell me?
No.
I'm going to follow the recommendation. All jail time will be suspended on the condition you have law-abiding behavior and pay, I believe, $150 fine was a recommendation.
That's correct.
You can pay that at the rate of $25 a month. Now, we're dismissing the more serious charges, assault in the 4th degree and the malicious commission of 3rd degree. But hopefully, this has been a learning experience for you and one to not be repeated. Agreed?
Agreed.
You take care of yourself. We'll send you copies of today's paperwork and likewise a copy of your attorney. And if you have any questions, make sure you give Mr. Crowe a call.
All right. Thank you.
Mr. Wilmot, thank you. And you take care of yourself and the best of luck.
You as well.
Thank you, Your Honor.
Well, thank you.
I don't think we have any put on the record, Your Honor.
We do have Mr. Altona from the.
Yes, I'm going to dismiss that with prejudice. He has been spent almost 3 years in the penitentiary, and I'm dismissing him.
That sounds like a reasonable resolution of the matter.
I guess we do have a couple warrants from our 815 count.
Do we need an order on Altoona or stuff? Brent, do you want a formal order on Mr. Altona or just dismiss it? Just dismiss it. And going back to the 8:15 calendar, Celine. That's fine. We have a Galaxy J3 orbit, but we don't have a name to go with that. Could you, you appear to be muted. Could you tell us who you are?
I'm Cyrus Rosnick. Sorry.
Who are you?
Cyrus Rosnick. I don't know if
It's Mr. Stevens' client.
did it unmute me here?
Yeah, I can definitely hear you. You're going to need to talk to your attorney who's here today.
Gotcha.
Now, he's going to need a phone number for you. Could
Yeah, I can give you all that.
Hang on 1 second. Okay. Okay, go ahead.
Mr. Robert?
253 290 2752.
And that was 360?
253.
Okay, sorry, I couldn't hear that. 253-290-2752?
Yes.
Okay, I'll give you a call in a few minutes.
Gotcha. Thank you so much.
And nobody else is on. Nobody else on the 8:15? Mr. Delia, so we can go through the
Yeah, let's do it.
8:15, start with Celine Alexander. That's on for a SOC review. Data violation back in 2018.
$5,000 cash or bond.
So ordered. The next would be Antonio Clark. He was picked up on his warrant. I released him on his absolute promise to appear.
This is assault 4, and then he's got a verb 2 or verb 1. Robbery 1.
Oh.
$10,000 cash or bond. He may be, I guess, may have been charged with that. This notes here on the form that there's a new offense noted. It doesn't have any resolution on that.
New violation, yes. Do we have a way of finding out? Yeah. We're going to check and see if he's being held everywhere.
So is that being held
But I don't know.
Yeah, $10,000 cash or bond.
So ordered. And the last one would be Brenda Sembrano.
There's another SOC, $10,000 cash bond.
So ordered. Everybody on the line is taken care of, except is Ashley Johnson in the courtroom by any chance?
I think Mr. Habico is speaking with us.
Oh, okay, great.
But she is here.
That's a reset on the warrant. Yeah. We can go up. Back on the record, we'll call the 9:45, 10, and 11 o'clock dockets. Mr. Abaco, if you have anything to put on the record?
I do, Judge.
We'll defer to you, and just let me know which docket they're on.
Yeah, on the 10 o'clock calendar, Judge, items numbers 1 and 2, Andrew Clark.
Mr. Clark, good morning.
We're gonna waive, I've gone over both cases with him. One is a new case. We're gonna waive arraignment on item number 2. He understands the charge, his rights, and we intend on entering a plea to that new charge. And then as part of the agreement, the city will move to dismiss the 2021 matter.
Here we go. Need to refresh this thing a couple of times. Mr. Clark, good morning. For the record, is your name Andrew Jason Clark?
Yes, sir.
Mr. Clark, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. Have you gone over the plea form with Mr. Haverco?
Yes, sir.
And if you had any questions at all about what it meant to plead guilty to a criminal offense, was your question answered? Yes. Now, if I accept the plea, give up the rights contained in paragraph 5, there's no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 364 days in jail and or a $5,000 fine. You realize that?
Yes, sir.
Again, Mr. Clark, if you had any question at all about what it meant, are you sure you've discussed this matter fully with Mr. Haverco?
Do you feel like I'm missing any details?
As to 1 count of theft in the 3rd degree, alleged to have occurred within the city of Yelm on June 3rd, 2021, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
Everybody in this court, right? No, sir.
And Judge, if I could just clarify, just to make it clear, he's pleading guilty to the February 6th violation.
Yeah, that's a ticket ending 3350. And as part of the agreement, the parties were dismissing the other charges.
Yeah, that's part of the agreement, Judge.
Mr. Clark, as to 1 count of theft in the 3rd degree alleged to have occurred on February 6, 2022, how do you plead guilty or not guilty?
Guilty, sir.
You make that plea of your own free will. You have to answer out loud, yes or no.
Yes, I thought we just did that.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
Find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Haverco, the recommendation is 364 days, all suspended on the condition that there be law-abiding behavior and a $250 fine. Anything to add?
Nothing, Your Honor. Just ask the court to follow the recommendation. Thank you.
Mr. Dilly, anything to add to the recommendation?
No, Your Honor.
Mr. Clark, anything you want to tell me? Anything you think I should know?
I appreciate it.
I'm going to follow the recommendation. 364 days in jail, all suspended on the condition you have law-abiding behavior. Stay out of trouble, okay?
I do my best.
We'll assess a $250 probation fee. We'll set your payments on that at $25 a month. Now, if making the payments becomes an issue, what I want you to make sure you do is contact Mr. Haverco, and that is something we can easily deal with. The most important thing is
Where do I make
law-abiding behavior. Stay out of trouble, okay?
Where do I make the payments at?
Mr. Clark, as part of the bargain, the ticket ending in 081 is dismissed. Now, we had a little difficulty getting you to come to court. I want to thank you for appearing today. You told me you would, and yet here you are. Now, whether you have to come back or not is going to be up to one person, and that's you. You stay out of trouble, okay?
Where do I make those payments every month at?
Any questions?
I think he asked where he makes payments, Your Honor.
Thank you.
Mr. Clark,
Soft spoken.
at the window, A, I don't hear as well as I used to. B, you're a little soft-spoken. And C, the acoustics in this room are terrible.
Sometimes when I actually speak, I can be a little intimidating, so I tone it down a little bit. Where do I make those payments at, sir?
At the window,
Thank you.
if you don't have the use of the mail, just make them at the window. Any questions at all?
No, sir.
Mr. Clark, good luck and thank you.
Thank you.
Next, if we could turn to the 10 o'clock.
Hold on,
Oh,
I'm still
yes,
reviewing
Judge.
the JNS. Okay, go ahead, please.
Thank you, Judge. So also on the 10 o'clock calendar would be number 4, Erica Fleming.
Ms. Fleming, come on up and have a seat.
And matter comes on for the court this morning for a pretrial hearing on a DUI, driving under the influence charge, and a charge of suspended driving in the 3rd degree. I believe the parties have reached a proposed agreement. She intends on entering an Alford plea to count 1, driving under the influence. We've reviewed the evidence pretty extensively, and she takes exception or issues with some of that evidence, but definitely. But she agrees that were the matter to go to trial, that based on her understanding and our discussion of the evidence available to the city, and if that were presented either to at trial, either to a jury or a judge sitting without a jury, along with whatever evidence that Ms. Fleming might have, she does agree there's a high probability that the fact finder, jury or judge, would enter a finding of guilt. And so because of that, she wishes not to contest the evidence. She may not agree with it, but she wishes not to contest it. The other reason, Judge, she's entering a plea is to take advantage of the city's plea offer, which is 1, a dismissal of count 2, the suspended driving 3rd count, and then probably the bigger thing is the city is willing to amend the charge, if you will, to that of a no test DUI, and the penalties associated with a no test DUI, which are substantially less than would be assigned with the original, test. And so, so with that in mind, yeah, I think we're ready to proceed, Judge.
Good morning, ma'am. For the record, is your name Erica Michelle Fleming?
Yes, Your Honor.
Ms. Fleming, I'm looking at a statement of defendant on plea of guilty to 1 count of driving under the influence of intoxicants. Plea form tells me you're 36 years of age. Did you have any trouble at all reading, understanding the plea form?
Well, and actually, Judge, just so to make it clear, I reviewed the electronic form with her, and I made it very clear. It's got her case name, her cause number, and most importantly, it contains a listing of her constitutional rights that she gives up by entering a guilty plea. And I went through each and every one of those rights, Judge, and so.
With it, let me rephrase that a little bit differently. Did you go over the plea process with your attorney?
Yes, Your Honor.
And you feel it's, what is involved in entering a plea of guilty to a criminal offense?
Yes.
Now, you do give up a certain number of rights contained in paragraph 5 on the plea form: no trial, no appeal, no witnesses. There's simply going to be a sentencing which could be up to 364 days in jail and up to a $5,000 fine. You realize that?
I thought that I would have to pay the $990.
So.
Oh.
Yeah.
Yes.
Yeah.
Ms. Fleming, I simply have to tell you that that's what could happen, not what will happen. There are certain, I'm sure you've gone over this with your attorney, there are certain mandatory things that I have to, and that's what I ordinarily do, but I need to let you know that what the possibilities here are. That's all. That's all. With that in mind, as to one count of driving under the influence of intoxicants alleged to have occurred in Yelm within the city limits of Yelm on December 16, 2021, how do you plead, guilty or not guilty? Take your time.
Oh, I think she.
I said I plead guilty. Your Honor.
Do you need a moment?
No, Your Honor, she said she.
That I caught.
Oh.
A little emotional.
Right.
You do that of your own free will? Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I will find the plea to be freely, knowingly, and voluntarily made. And according to your attorney, this is what they call an Alford plea, which means you don't really agree that you did anything wrong, but you realize you've gone over the information that the city has, and if the matter were to go to a trial, to either a judge or a jury, things could go pretty bad based upon what the city has to present. Do you realize that?
Yes, Your Honor.
I do find a factual basis based on the record and the breathalyzer. And it's a stipulated no test result, I
Correct.
understand. Anything further with regard to sentencing?
Oh, nothing. Yeah, we're ready to proceed with sentencing, Judge.
Do you know anything further about sentencing?
Nothing further, Your Honor.
Ms. Fleming, you have a right to tell me anything you think I should know about you, your situation, about the case before I impose sentence. You don't have to say anything, but if you have anything to say, now's the time.
So you don't have to. If you want to, if you want to comment on the case or there's an opportunity to say.
Well, I have a question, if I can ask that.
Sure.
Is it gonna make a difference? Because there's a lot of misinformation that was in the police report. But because it's a police report, is it gonna make a difference if I tell you, or is if I need entering the alpha plea, then it's just gonna be that, and the sentence is up to you. I don't understand how we move forward. I go to say, okay.
No, you're not agreeing that everything is right. You're not agreeing with that at all. That's why it's called an Alford plea. All you're agreeing to is that the city uses that evidence against you, that the jury or the judge could find you guilty of that based on what they have, regardless of what you say. That's what an Alford plea is. I realize that, yeah, a lot of people, they disagree with the facts that are set forth in a police report, but it all comes down to what a jury believes or a judge believes and what each side can present. And that's one of the risks of going to trial, is nobody really knows what's going to happen until a jury makes a decision. And that's why people enter a plea of guilty, to take advantage of the disposition that's agreed to, rather than take a chance of something much worse happening. Okay?
That's what I'm trying to do.
I'm going to follow the recommendation, which is the mandatory minimums, 364 days in jail, 1 day you have to serve, but the other 363 suspended on the conditions that I'll address in a minute. Is there asking for the alternative day? Or?
She doesn't know if she's going to do that, but I would request that the court authorize her to serve the day in jail, including on the City of Olympia alternative DUI jail program, and that the court give her 120 days in order to do that. She has had an evaluation. I haven't seen it, so I'm not aware of what the recommendation is. And so she's apparently done that. And I've gone over with her that, if all that's recommended from the eval is alcohol drug information school, I've gone over with her that she could elect to do that along with the victim impact panel together while serving her day in jail through the city of Olympia. And it's kind of a bargain in a sense because you knock out your day in jail and then the costs include the two classes. And so, so she's, I think, just going to think about her options. And I think the city was asking for 24 months of jurisdiction, and we don't have an objection to that. And we just ask that she be given a time payment agreement so she has plenty of time to pay, and that'll make her payments fairly low.
This, I mean, that's one thing I have to do is order that you get a drug and alcohol assessment and comply with any recommended treatment. And of course, yes, you can have up to 120 days to do the City of Olympia alternative program. It's a very good program, and it's educational, and maybe a little better than sitting in a jail cell for 24 hours. The fine, it's mandatory, $990.50. That to me is the least important thing. If you can't pay that, let us know. Get a hold of Mr. Haverco. That is something we can easily address. Don't drive unless you're licensed and insured. Have no criminal law violations. And I'm hoping that you sail through the evaluation process. The breathalyzer result that you gave were concerning, to say the least. That's one of the higher ones that I've seen in a long time. I'm going to wish you the best of luck. You take care of yourself. And what we really want to make sure is that nothing like this ever happens again. You never get behind the wheel of a car when you've been drinking. And of course, comply with any sanctions that the Department of Licensing imposes upon you as a result of the conviction. They will take action against your driver's license in a manner reflected by your driving record and by the fact that there is no test result. Any questions at all, Ms. Fleming?
Yes, Your Honor. How do I do payment plans?
How do you pay the fine? You can pay it in the order, it will say $25 a month. And again, if you have trouble making the payments, just let us know. And of course, the earlier you get it paid off, the earlier you can forget about it. To me, the most important thing is the evaluation and complying with any treatment, not the fine. But I really don't want to see you put yourself in this position ever again.
No offense, but you will never see me again.
That's up to one person, and I'm looking at her. I wish you the best of luck.
One more signature.
Now, Ms. Fleming, we do have a probation monitor, and her contact information will be on the judgment and sentence form. And she will help you comply with the terms of the sentence as best as she can.
What's that? You're only, well, there's they have a part-time person whose job it is just to work with you, make sure you get treatment. So we call them a probation. It's not a DOC. They're just monitoring you to make sure you do what you're supposed to do. Yeah.
Okay.
Yeah. If you have any questions about stuff, you can call that person. Right. They're really good about it. Okay. All right. Good luck to you.
Fleming, everything is done electronically. Now you can get a copy of today's papers, and I want you to do that by going out the front door of the courtroom, then going to your left, there's a glass window, and ask for a copy of today's hearing. Review it carefully, and again, if you have any questions, that's what we're here for. And Mr. Haverco, of course, is your first contact. Good luck to you.
Thank you, Your Honor.
Thank you, Ms. Fleming.
And
Part of the plea bargain, this third charge is dismissed.
Ms. Johnston?
Good morning. Is this
This is the,
Ashley Johnston?
yeah.
Good morning, ma'am. Address that matter now. I'm looking at an SOC.
That's correct, Judge. So, yeah, I've had an opportunity to meet with Ms. Johnston, review her case. She doesn't have a prior criminal record. By agreement, the parties are proposing the court accept a stipulated order of continuance, the conditions of which would be for the next 12 months to not commit any criminal law violations, pay a $250 probation fee, at the end of which time the city, as part of the agreement, would move to dismiss the case.
Ms. Johnson, Mr. Everco's worked out an agreement with the city on your behalf where you can get this charge dismissed if you comply with the conditions set forth in the agreement. Most important one is stay out of trouble. No criminal law violations. Lesser in importance is a $250 probation fee. Now, in return for this agreement to get the charge dismissed over time, 12 months to be exact, you've given up your rights to go to trial, have witnesses, appeal if you get a bad verdict in the case. And in return for that, if you violate the agreement, the city approves that without hearing, simply based on the police reports, and that would result in more likely than not a finding of guilt and the possibility of a significant jail time. We don't want to go there. You have a chance to get the charge dismissed. I'm hoping that you take advantage of that. I'm putting my signature on the SOC, stipulated order of continuance. I want you to take a copy of this with you. You can get that at the glass window outside and to the left. And of course, if you have any questions at all, give Mr. Haverko a call. Any questions?
No.
I'm going to wish you the best of luck, and I want to thank you for appearing.
Yes, thank you so much.
Thank you, and you take care of yourself.
That's it. Yep.
Thank you.
Josh? So sign right here. Okay. So this is Josh McCrevin. He is docket numbers 8 and 9 on the 11 o'clock.
Mr. McCrevin, good morning.
Good morning.
So he's going to enter a straight plea of guilty to the charge of DUI. It's in the nature of a no test, mandatory minimums, and we're ready to proceed.
McCrevin, for the record, is your full name Joshua James McCrevin?
Yes, sir.
Mr. Crevin, I'm looking at the statement of on plea of guilty to one count of driving while under the influence of intoxicants. That charge is what they call a gross misdemeanor. The maximum penalty for that would be on conviction 364 days in jail and or a $5,000 fine, which I would be free to impose regardless of what's recommended. You realize that? Plea form tells me you're 30 years of age. Have you gone over the form with your attorney?
I don't believe so. Okay.
We've more particularly, we've gone over the guilty plea process telephonically, and I've discussed with him that there's an electronic statement of defendant on plea of guilty. And I went over with him the listing of his important constitutional rights that he has, that he gives up upon entry of a guilty plea, namely his right to trial, his right to appeal, question witnesses, testify, not testify. So we did discuss that thoroughly, Judge.
Mr. McCrone, it seems like everything these days is on a computer screen rather than on paper, which I pretty much grew up with at my advanced age. But you have discussed the plea process with your attorney and feel you understand what's going on?
Yeah.
Now you give up by pleading guilty, you give up the rights contained in paragraph 5 of the form. No trial, no appeal, simply a sentencing, which could be up to the maximum. And with this charge, there are, mandatory minimums, they call it, which I'm inclined to impose unless there's something I don't know about. With that in mind, as to one count of driving while under the influence of intoxicants, alleged to have occurred within the city of Yelm. On June 19th, 2021, how do you plead guilty or not guilty?
Guilty.
Kevin, do you make that plea of your own free will?
Yes.
Anybody make any threats or promises for you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. And as a result of the plea, the Department of Licensing will take action against your driver's license in a manner reflective of your driving record and the breathalyzer level. Mr. Havercoat, with regard to the recommended sentence?
It's an agreed recommendation. City's willing to treat it as a no test DUI situation with mandatory minimums of 1 day in jail, $990.50 for a fine. Ask the court, if he elects to do it, ask the court to give him 120 days within which to serve his jail time, whether or not he wants to serve it, I assume at no cost within a Nisqually jail, or rather if he wants to serve the day in jail through the City of Olympia DUI alternative jail program.
City, have anything to add?
Nothing, Your Honor. It's agreed order.
Mr. McCrevin, do you have a right to tell me anything you wish? You don't have to say anything, but if there's something you'd like me to know, something about the case or yourself, now's the time. I think it's the recommendation is a fair one. Hopefully this is a first and last time DUI. All you have to do is pick up a newspaper and you read about at least one, sometimes often more, fatality, a bad result that happened as a result of somebody drinking and then getting behind the wheel of a car. I am going to do impose the mandatory minimums. I don't have any choice about that. 364 days in jail, 1 day you have to serve. The rest of them, the days are suspended on the conditions I'll set forth in a minute. And the 1 day you can do at the City of Olympia Alternative Program. It's a great program and it's a little educational, and it sure beats sitting in a cell for 24 hours.
One sign here, and that one too. Sign your judgment sentence.
Conditions of sentence are law-abiding behavior, stay out of trouble. Don't refuse to take a breathalyzer if asked to do so. No criminal law violations. And comply with any mandated treatment by an evaluation for drug and alcohol usage. You have a copy of the list of agencies that can provide you with that service. Mr. Krevin, that if we don't learn from our mistakes, we're condemned to repeat them. I'm going to wish you the best of luck. Hopefully you'll sail through this. It's kind of a rough one in terms of your license, insurance, et cetera, but as time goes by, all those requirements go away and it's back to a normal life. Whether that happens or not is up to you. Good luck to you.
Thank you.
Now, I'll sign the final papers and you'll be able to get a copy of that at the window outside the room to your left. Good luck to you, Mr. McCrevin.
Thank you.
I think Mr. Stephen may have some matters raised.
And before we take them, I'm going to need to catch up with the electronics.
Gotcha.
I'm caught up.
You're caught up? Okay. Thank you, Your Honor. So I have a couple of live bodies here that are just reset, so I want to call those real quickly and get them out of here. I'll start with Mr. Wilson. Mr. Wilson's number 12 and 13 off the 10 a.m. calendar. I have a motion to reset this, I believe, with the waiver on times for trial. We're going to have that restart when we reappear. We have a couple things we want to get done in the meantime. I believe I asked the commencement date to be the 12th of May, so I'd like the court date to go to that date if possible.
For the record, you're Michael J. Wilson. Yes, sir. For resetting the matter, we're getting to court date now. At the request of yourself and your attorney, any criminal case deserves as much time and attention as you can give it prior to proceeding to any sort of resolution or any further course of action. We're resetting your case to May 12th at 10 in the morning. I'll sign off on the order resetting at the appropriate time. And I want you to get a copy of this at the window. Any conditions of release earlier set remain in effect. And of course, maintain contact with Mr. Sneva in the meanwhile, okay? Mr. Wilson, any questions?
No, sir.
Good luck to you. You take care. We'll see you at your next court appearance.
Thanks, sir. All right. Thank you. Good to go. Local line. And all these are going to be resets to the same date. We have things to do in each one of them, and I want to make sure we can accomplish those, so we come back with something accomplished, Your Honor. This is Lokalani.
Ms. Villegas, good morning.
Villegas, number 7 off the 10 o'clock. We're also asking to just reset this to the 12th of May.
Ms. Villegas, so we will reset your matter to May 12th, 11 o'clock in the morning. In the meantime, law-abiding behavior, stay in touch with Mr. Sneva, and I might indicate, Mr. Sneva, that I know Ms. Villegas from the Squally Tribal Court, and if that proceeds, causes any distress, I'll gladly step down. I'll be willing to hear the case if the parties are in agreement on anything, but if there's a contested matter, I probably have to I would have to step down.
Understood, Your Honor. And at this point, we're comfortable moving forward. We
discuss that matter when you have.
I will do that. Thank you.
Ms. Villegas, you take care of yourself. We'll see you here on May 12th.
The next matter, Your Honor, is Miss Wells. Similarly, we've got a couple things we're going to be doing in this matter. So we're asking to set this out to the May 12th as well.
Again, at the request of yourself and your attorney, resetting the matter to May 12th. And again, I'll indicate that I know Ms. Wells from the Squally Tribal Court. If that presents a problem, I'll be glad to step down. But that needs to be discussed between the two of you.
Understood. Thank you, Your Honor.
So as I've signed the order resetting the matter to May 12th. Good to see you. You take care of yourself, and we'll see you in the middle of May.
Thank you.
Thank you, Ms. Wells. Thank you. Take care.
We'll be in touch. Thank you. Next matter I have, Your Honor, is off the telephone. Mr. Rosnick. Or off the Zoom, I should say.
Cyrus James Rosnick. Mr. Rosnick, good morning. You're muted. If you unmute yourself, we'll take your matter now. Your attorney's in the courtroom.
Gotcha. Can y'all hear me?
I certainly can. Thank you.
All righty.
And Your Honor, Mr. Rosnick and I have spoken. This matter comes on for a pretrial. We're going to be entering a plea of guilty to counts 1 and 2, vehicle prowl and theft 3. Upon successful entrance of that plea, count 3, obstruction, would be dismissed. We are asking with an agreed recommendation of a $250 probation fee and restitution being reserved in that matter. It is an agreed recommendation, so we're asking the court to accept that plea today. Thank you.
Mr. Rosnick, first of all, is your full name Cyrus James Rosnick?
Yes, Your Honor.
Disagree at all with anything your attorney just said?
Yeah.
Do you disagree with anything I just said? That was a question, Cyrus.
Oh, no, sorry. I do not disagree with anything you have said.
You're good. We're just checking. Thank you.
Thank you. That's what I assumed you meant, Mr. Rosnick, but I wasn't quite sure. Anyway, this plea form tells me you're 21 years of age. You've been through the 10th grade.
Yes.
And it also tells me you're any pleas of guilty to a vehicle prowl 2nd degree and theft 3rd degree. Is that correct?
Yes.
Now, the maximum penalty for each of those charges would be 364 days jail and or a $5,000 fine, which I would be free to impose regardless of what's recommended. You realize that?
Yes.
And if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal. There'd be simply a sentencing, and that would conclude the matter.
All righty.
With that in mind, as to 1 count of vehicle prowl in the 2nd degree and 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on January 24th, 2022, how do you plead guilty or not guilty?
I plead guilty.
You make those pleas freely and voluntarily?
Yes.
Anybody make any threats or promises to you that make you plead guilty?
No, Your Honor.
I will find the pleas to be freely, knowingly, and voluntarily made.
Yeah.
And your statement in paragraph 11 does satisfy what they call the factual elements of the offense. So, Mr. Steve, anything further with regard to the sentence?
Just that he's taking responsibility at his first opportunity to do so, Your Honor, and we're asking that the court, very minimal criminal history, we're asking that the court follow this. Thank you.
Mr. Dilly, anything to do with that?
Nothing further, Your Honor.
Mr. Rosnick, you have a right to tell me anything you wish. You don't have to say anything, but if you can rely on the statements of your attorney, but if you do have anything you'd like me to know, now's the time.
I have nothing.
Mr. Rosnick, I'm going to follow the recommendation, 364 days in jail on each charge, all suspended on some conditions. One is a $500 probation fee, $250 per case. We're going to reserve restitution. If there isn't any restitution claimed by now, it's kind of doubtful that we're going to get one. But if we do, you're entitled to a hearing on that. Law-abiding behavior, stay out of trouble.
I do have one question.
Certainly, go ahead.
So when I pay the fine, do I go straight into the city hall there?
Yes, you can come to the courthouse, and if you're going to pay it in person, just go to the clerk's window, and you can make your payments there.
All righty, thank you.
Also can mail them in, and if you mail them in, put your ticket number. That's a number ending 181. Make sure you put that on any check you send in.
Gotcha.
Any other questions?
I do not have any others.
Hey, Mr. Rosnick, I want to thank you for appearing. Thank you for your patience. You take care of yourself. We will be sending you a copy of today's paperwork, and you take care of yourself. Good luck.
All righty. Have a great day.
You too.
Do I need to sign that? Okay. Well, let me bring that up.
And Brett will need a signature on the JNS at the when it shoots over. And for the record, obstructing is dismissed.
For the record, Your Honor, got a couple of dismissals. I'm not speaking for all. Folks, Doncaster, Michael, that's number 3 on our calendar, city dismissing without prejudice.
Michael Drew Dunn.
No objection, Your Honor.
On the 11 o'clock calendar, Tracy Castellita, and that is number. Castellita is number 3. Both charges. City has a couple of issues with this, namely, all the officers involved are no longer with Yelm.
They've had that happen more than once, which does make it difficult to proceed with the prosecution. Citing on Doncaster. Citing Castaneda.
Are we ready for another matter, Your Honor?
We are.
Okay, if we could take Mr. Bennett, he's on Zoom on the 11 o'clock calendar.
Mr. Bennett, good morning. We'll take your matter now. You need to unmute yourself. Your attorney's in the courtroom. As soon as you unmute, we'll address your matter.
Hello?
Hello, Mr. Bennett. We now hear you. I assume you can hear us correctly. Your attorney's in the courtroom. I'll defer to him to give us the status of the matter.
Thank you, Your Honor. This matter comes on for pretrial. We do have a resolution for this matter that's been worked out. This is going to be resolved by way of an amendment to assault 4th degree non-domestic violence that's been noted in the stipulated order of continuance form, and then a 12-month SOC with no law violations. He is going to be allowed, this is involved his brother. He's going to be allowed to be with his brother. He obviously just can't have any law violations. And so he's going to have to not have this or anything like this happen again. And he understands that. I've gone over that with him. There'll be a $250 probation fee. And we're asking that the court accept this. And no criminal history either, Your Honor. Thank you.
Thank you, Mr. Stephen. Mr. Bennett, do you disagree with anything at all your attorney just said?
No.
He's worked out a contract with the city on your behalf where this charge, 12 months on their own, can be dismissed if you abide by the conditions that are set forth within the order. You understand that?
Yes, sir.
The conditions mostly are, most important to me is stay out of trouble. No criminal law violations, especially when it involves family members.
Yes.
The other one is a probation fee in the amount of $250, which you can pay over time.
All right.
Now, in return for this agreement, you've given up your right to go to trial, the right to have witnesses appeal if you lose at trial. If you violate the agreement, the city proves that. We'll have a hearing based on the police reports, and you know where that would leave us. That would leave you with the possibility of a conviction and significant jail time. We don't want to go there.
No, we do not.
We'll get this charge dismissed, but you need to take advantage of the position your attorney has put you in. Any questions?
No, sir.
Mr. Bennett, I'm going to wish you the best of luck. We'll be sending you a copy of today's agreement. And I should affirm for the record, your full name is Conan Xerxes Bennett.
Yes, sir.
I want you to review this, the contract, and then if you have any questions about it, give Mr. Sneed a call, okay?
All right. Thank you.
Thank you, Mr. Bennett. Good luck to you and take care.
You as well.
Mr. Williams on the line? And Mr. Williams, can you hear me?
Yes.
Williams, good morning.
Good morning.
Your Honor, this matter comes on for a pretrial. This is Titus Williams. I'm going to ask to reset this matter today. Mr. Williams, do you have a pen so I could give you my phone number?
Yes, 1 minute.
I haven't had a chance to speak with Mr. Williams yet, and Your Honor, there's also a deferral that's going to be tracking this that I'm not appointed to yet that I think I need to be appointed to. That's 1A0065494. I just wanted to bring that to the court's attention. Excuse me, before we move forward. Mr. Williams, are you ready?
Yes.
All right, my phone number, my name is Josh, and my phone number is 360-890-6847. And I'm the attorney that's been assigned to your case. For today's purposes, I'm going to ask to reset this approximately 6 weeks so you and I can have a chance to meet and discuss the case. And we'd go out. I'm going to ask for, is the 14th the next? Is that 6?
April 14th.
I'm going to ask for April 14th. Could you give me a call before then?
Yes.
Okay.
Mr. Williams, in a moment, I'll be signing an order resetting your pretrial hearing to the 14th of April. In the meantime, keep in touch with your attorney, law of any behavior, and we'll talk to you then. Any questions at all? You need to unmute yourself if you want to speak.
No, I have no questions.
Hey, Mr. Williams, thank you. You take care. We'll be sending you again a copy of the order.
Okay, thank you.
Thank you.
Thank you, Mr.
And Your Honor, just let me know when you're ready. I think I have the rest of my calendar completed. I just have to go through them. Like, we know what we're doing on.
Go back to what they call the dashboard.
All righty.
Go.
I believe the next matter that we haven't yet dealt with is Sarah George. I spoke with Miss George on the phone just a few moments ago. This is a case I'm going to need to speak with the alleged victim as well as her and go over this. We hadn't spoken until just recently. I have there's a waiver in there as well. I'm going to ask to set this out to that same April 14th date if possible. Thank you.
Sarah Elizabeth George. Reset to April 14th. We'll be sending her a copy of the
Next matter, I believe, unless I'm missing something, is, oh, sorry.
Any shot, any shot. Do this. Go ahead.
I believe the only matter I have left is Will Seibert's. Mr. Seibert's and I are working to try to resolve this matter. He's working on some restitution that we're communicating or trying to communicate with the other side on. So we're going to need some more time, and it's quite a hefty dollar amount. So we're going to ask for the May, that May date that I've been using. I think it's May 12th. Is that right? Yeah, May 12th, please. Noting the FTA for the purposes of speedy trial.
May 12th, 10 o'clock. No penalty bears for speedy.
I believe that's everyone, unless I'm missing something. Thank you.
Let's see. Josh, you take care. Yeah, I
Alrighty.
think that is, a brief scan tells me that that is it for you. You take care.
All right.
Be well, and see you in a couple.
See you soon. All righty. Thank you.
Oh, boy.
We can take this for Bill Cox on the, I believe, 11 o'clock.
Good morning, sir. For the record, is your name James Arthur Wilcox?
Yes, sir.
Go ahead and have a seat. I'll defer to your attorney for the status of the matter. I'm looking at an SOC in this case.
Yeah, and I'm trying to, I don't know whether I need to re-log into O Courts or not. Previous document I was on is not close. Well, if it's in the system, I did prepare it, but I may have to bring it back up for him to be able to sign it, because it's not. Can't see it.
I have it. You signed off on it.
Let me see if I can at least get his signature. Yeah, it's not reacting. I think I'm gonna have to, just give me a quick second here and we just bring back. Just take me a second. Sign back in. There we go. Just about there. It's working. Let's see. Okay. I'll have you sign that now. Okay, go ahead and sign it. So the parties are have an agreement. We're proposing the court accept a stipulated order of Oh, sorry about that. Sorry. There you go. There you go. There we go. He's affixed his signature, so we're proposing a stipulated order of continuance. The matter be continued for a period of 12 months on the condition that he not commit any criminal law violations. He has no prior convictions. And they pay a $250 probation fee, and at the end of which time the city would then move to dismiss.
So Wilcox, I'm looking at what they call a stipulated order of continuance, which in reality is a contract. It's an agreement negotiated by your attorney with the city under the terms of which, if you comply with the agreement, guess what? 12 months down the road, this charge is dismissed. It will not go on your record as a conviction. The conditions, of course, you can guess what they are. Law-abiding behavior, stay out of trouble, especially when that comes to abiding by the terms of any no contact program. Pay a probation fee in the amount of $250. No criminal law violations. Stay out of trouble. That's very important. And if your address, contact information should change, let us know that, and at least let your attorney know that, okay? Excuse me, you're in a position of getting the charge dismissed. Whether you do that or not, it's up to one person, and I'm looking at it right now. Good luck to you. You take care. You can get a copy of this agreement by going to the window outside the courtroom and to your left. I want you to review that carefully. Don't lose it. And if you have any questions at all about what it means, contact Mr. Hammond. Yes, sir. Good luck to you. Thank you.
Is there anybody else? So it looks like we've got a Mr. Kirkus on the line. On the 11 o'clock. Do that.
Mr. Kirkus, is he still there? Mr. Kirkus, good morning, yep, still morning. You're muted. Thank you. Can you hear me?
Yes, sir. Can you hear me now?
We certainly can. We'll address your matter now. Your attorney's in the courtroom. Mr. Haverhill?
Thank you, Your Honor. So this is a matter of John Kirkus, and we've had an opportunity to discuss this case, and the parties are proposing the court accept a stipulated order of continuance of which I've prepared. And essentially matters continued for a year with the dismissal if he complies, no new criminal law violations, pay a $250 probation fee, and then reserving the issue of restitution.
Mr. Kirkus, for the record, name is John Kenneth Kirkus. Is that correct?
Yes, sir. Yes, sir.
Your attorney has negotiated with the city an agreement under the terms of which you can get this charge dismissed if over the next 12 months, you stay out of trouble, no criminal law violations, pay restitution. If that becomes an issue, you are entitled to a hearing on that, but we don't have any restitution to set at the moment. Pay a probation fee in the amount of $250. If you do that, at the end of a year, this charge is dismissed. If you violate the agreement and the city proves that, we'll have a hearing based on the police reports, and that would result in the possibility of a conviction and for a criminal offense and the possibility of jail time. We don't want to go there. You have a chance to get this matter gone, so please do so.
All right. Yes, sir.
Kirkus,
What's that?
any questions at all?
No, sir.
I'm going to wish you the best of luck. You take care of yourself, and again, we'll be sending you a copy of today's agreement. Read it over carefully, and if you have any questions at all, give Mr. Haverhill a call and resolve the issue, okay?
Yeah, the only question I do have is I can just show up to the courthouse and pay $250 fine.
Could you repeat that?
Did I just go up to the courthouse there and pay the $250 fine there?
Yes.
Okay.
You're asking where you can pay this?
What's that?
If I understand it, did you ask me if, where you make the payments on your, the probation fees?
Yes, sir. It's at the courthouse, correct?
That could be right here. If you mail a payment in, what I want you to do is put the ticket number on it. That's that number ending in 091.
Okay.
But good luck to you. You take care. Thank you for your patience and you have a good day.
Yeah, you too. Thank you. Bye.
We're on record, but the attorneys have left the courtroom. Mr. Baker, good morning, you're muted. Mr. Haverco stepped out of the courtroom. We'll address your matter once he comes back in. But go ahead, unmute yourself.
Unmute. There you go. Okay.
Thank you. Once again, yeah, Mr. Haverco stepped out of the courtroom for a moment, but we'll take up your matter when he comes back in. Thanks for your patience.
Yes, sir. Thank you. So where did your mom go to?
What'd you say?
So where did your mom go to?
Mr. Baker.
Yes, sir.
Address your matter at this time. I'll defer to you.
The matter of Joel Baker comes on for a pretrial hearing on a couple of theft counts. I believe the parties have reached an agreement. He's going to do a straight plea of guilty to, it doesn't matter which count, just one of the counts. And then upon the court's acceptance of that plea, then the city will move to dismiss the other count. And recommendation is to suspend jail time for the next 12 months. Don't commit any new criminal law violations, and don't pay a $250 probation fee, and then the case will be closed.
That's all correct, Your Honor.
Good morning, sir. Is your full name Joel Richard Baker?
Yes, sir.
Baker, I'm looking at a statement of defendant on plea of guilty that tells me you're 45 years of age. Did you have any problems discussing the plea process with your attorney?
No, I did not.
Now, the plea of guilty would be to one count of theft in the third degree. The maximum penalty for that would be 364 days in jail and or a $5,000 fine. I would be free to impose that regardless of what's recommended. You realize that?
Yes, Your Honor.
And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. And that would conclude the matter.
Yes.
With that in mind, with regard to one count of theft in the third degree alleged to have occurred within the city of Yelm on January 27th, 2020, are you plead guilty or not guilty?
Guilty, Your Honor.
Make that plea of your own free will.
Yes, I do.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea process. I've heard the recommendation as to sentence. Is there anything you'd like to tell me?
I apologize, Your Honor, for my behavior that day. And I will stay out of trouble.
That's the important thing is yes, we need to learn from our mistakes. If we don't learn, we're sort of condemned to repeat them. I'm hoping that this will be a learning experience. The second count is dismissed. Mr. Dilly, anything further with regard to sentence?
No, Your Honor, it's joint recommendation.
Yep. 364 suspended, $250 probation fee. You can pay that at the rate of 25 a month. Conditions of the suspended jail time are really basically one. No trouble, stay out of trouble, law-abiding behavior. And if for any you change your contact information, move, let us know what that is, okay?
Yes, Your Honor.
Mr. Baker, we're going to be sending you a copy of today's statement of defendant and the judgment and sentence. Review it carefully, and if you have any questions at all, give Mr. Haverco a telephone call, okay?
Okay, thank you.
Mr. Baker, thank you for your patience. You take care and have a good day.
Okay, good day.
Please back. Okay.
You got one more?
I do.
That happens. That's.
We reset that one?
Sure.
Brian Justice, we're going to take your matter now. Mr. Justice, are you able to hear me?
Yes, Your Honor. Can you hear me?
I certainly can. Mr. Averco, your attorney's in the courtroom. I'll defer to him for the status of your case, which is set for a pretrial at this time.
Thank you, Your Honor. This is Dan Haverco here on the line. Mr. Justice, I've been needing to chat with you about your case, but so I would suggest that we reset this case 2 weeks. And do you have a phone number I can reach at, Mr. Justice?
Yeah, it's 360-570-0359.
Okay. So what we'll do is we'll just I'll make a motion to continue your case for 2 weeks. And in the meantime, I'll chat with you on the phone and we'll get your case ready for next court date, which will be in 2 weeks. Is that okay?
Sounds good.
Mr. Justice, in a moment, I will sign an order resetting the matter. And that order will have within it the contact information with Mr. Haverco. It's very important you stay in touch with him to make progress on the resolution of your case one way or the other, okay?
All right, thank you.
Take care, have a good day.
You too.
And I'll need we'll need a motion. Oh, I need to. There it is. There it is.
I've signed it.
I keep forgetting to hit the refresh button. Got it.
Wow, and there's only like 2 no-shows today?
We had a pretty good appearance rate here.
Yeah.
Hey, Dan. The no-shows. Had a very good appearance rate today. That would be. First one I have is Robert Forgy, page 7, docket number 5.
And it looks like he also has warrants out of Thurston County District.
Thurston County District Court is likewise interested in the.
$5,000 cash or bond.
Mr. Abaco, any,
No, no contact, Judge.
the box requiring personal appearance has been checked. So ordered, 5K, cash or bond.
The last one I had is Jonathan Knowles. John Knowles.
Yeah, don't have any contact information, Judge.
I PR'd him on George Washington's birthday, February 22nd. I told him that he needed to be here.
How about $10,000 cash?
So ordered. the interpreter on Zoom, but we don't have Ms. Bowden or her client yet. Hey, Dan? May as well, we're waiting, still waiting on the telephone.
Okay.
For a non-record, I'll call the 1 o'clock arraignment calendar. Good afternoon to one and all. Before I call you up one at a time, I need to advise you of a thing or two. You have a right to have a lawyer represent you at all stages of any criminal proceeding, including today's hearing, which is an arraignment. Typically, a plea of not guilty is entered at this time, and the matter is set for a pretrial. Give you a chance to talk to your lawyer about the matter and decide whether the case is settleable without having to go to trial. If that can't be done, you do have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. Your most important right at this point is the right to have a lawyer represent you. Mr. Haverco is a public defender, and I'll appoint him to represent you. If you're indigent, you qualify, but he will at least enter a plea on your behalf and represent you for purposes of this hearing. And we'll discuss with you your qualifications out of my hearing. If you have any questions about what you're charged with or your rights, go ahead and ask either Mr. Haverco or myself any question you might have. Is Tasha Aronson here? Ms. Aronson, come on up and have a seat next to Mr. Haverco. Is your full name Tasha Marie Aronson?
Tasha Maria.
Citation I have alleges that on or about February 19th, 2022, you committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will ask Mr. Haverco to enter a plea on your behalf at this time.
Thank you, Your Honor. Would accept service of, the complaint, stipulate to probable cause and ask the court to enter a not guilty plea.
Probable cause simply means that the officer had a sufficient reason to issue you a citation. That's a long way from proving that you committed any criminal offense by evidence beyond a reasonable doubt. That preserves your rights and gives you the chance to discuss the matter. Plea of not guilty has been entered. We're going to set the matter for a pretrial on April 14th at 11 o'clock in the morning. Now I'm going to sign an order to that effect. When you leave here. Mr. Deli, good afternoon. Any other requests with regard to this matter?
No, Your Honor.
Is it 6567? Okay. So I'll be calling you.
Sir, and that concludes today's hearing. Conditions of release, of course, are law-abiding behavior, and stay in touch with Mr. Haverco. If any contact information changes, let him know immediately, okay? Do you have any questions?
No.
Take care. We'll see you at your next scheduled date. And again, get a copy of today's order by going to the window outside the courtroom and to your left. Good luck and thank you.
I don't, but they're going to give you a copy of paperwork.
Okay, all right, thank you very much.
Miranda Aschenbrenner in the courtroom. I do not see her. How about Jeremy Brissett? Likewise, we are waiting, Mr. Dillon, we're waiting for Ms. Bowden on docket numbers 4, 5, and she also has a pre-trial scheduled on with regard to docket number 7, but we'll wait for her.
All right, sounds good.
Is Joshua Kahn in the courtroom? Mr. Kahn, come on up and have a seat if you would. Is your full name Joshua Bernard Kahn?
Yes.
Mr. Kahn, the citation I'm looking at alleges that on or about February 15th of this year, 2022, you committed the offense of violating the terms and conditions of a no contact order. There's 2 counts. I will appoint Mr. Haverco to enter a plea on your behalf and represent you if you qualify. Mr. Haverco?
Your Honor would stipulate to probable cause and ask the court to enter not guilty pleas to both counts.
Mr. Kahn, a plea of not guilty has been entered on your behalf. And once again, you need to abide by the terms and conditions of any existing no contact order while the matter is pending and have general law abiding behavior. We're setting a court date for, I'll have it in a minute.
Write your phone number down real legibly.
March 31st, 11 in the morning.
All right, thank you, Your Honor.
Mr. Doe, any input in this matter?
I've heard from the victim in this matter, Your Honor.
Yeah, 970-685.
Scott, I assume the order of protection is still in place. It's very important that you abide by
Yes.
the no contact order. At a certain point, the charges get more serious.
Right.
So you are resetting setting the pre-trial.
Also, I'm taking DB classes to the Thurston County Court and the DB counseling.
Now, this is that's something you need to discuss with your attorney, and that all
Sign
comes
right
up
here
in later
on
days.
this electronic pad.
So I am in treatment.
Donnie, how do I do that again? I can't get it off of the. I try to sign it, and close it, and which then nothing happens. There we go. Finally got that to close. The court system is not working as well as I would like it to today. Mr. Khan, thank you. Again, get a copy of today's order by going out the courtroom door and go to your left and stay in touch with Mr. Haverco.
I will. Thank you.
You take care.
Thank you, Your Honor.
Nathaniel Nevalaska. Mr. Nevalaska, come on up and have a seat if you would. Good afternoon. Is your true name, full name, Nathaniel Owens Nevalaska? Nathaniel Owens Nevalaska. There's a way to mispronounce a name. I will do it. This citation alleges that on or about February 26, 2022, you committed the offense of driving while under the influence of intoxicants. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to enter a plea on your behalf. at this time. Mr.
Thank
Haber?
thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
The Alaska plea of not guilty has been entered on your behalf. We're setting the matter for a pretrial on March 31st. We'll give you the order setting that date and giving you contact information with Mr. Haverco. Given the nature of the charge, the conditions of release are don't drive unless licensed and insured, don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do that, and if your contact information changes, promptly notify your attorney. Any question at all? Mr. Dilly, given the nature of the case, any requested additional conditions?
No, Your Honor, not at this time.
Oh, let's get it. I'll sign the order. Please get a copy of that out the front door and then to your left. Good luck to you. You take care, and we'll see you at your next court appearance. Is Antonio Herbert Ray here in person or on Zoom? How about Timothy Thorne? Timothy Thorne. Bert Turner. Mr. Turner, come on up and have a seat if you would. Good afternoon. Is your full name Bert Lee Turner?
Yes, sir.
Mr. Turner, the citation I have alleged in honor about January 14th of 2022. You committed the offense of driving the license suspended or revoked in the second degree. The charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you, and he will enter a plea on your behalf at this time.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter a not guilty plea.
Turner, a plea of not guilty has been entered on your behalf. Again, that preserves your rights. Now, the conditions of release are law-abiding behavior, and of course, that includes don't drive unless you're properly licensed and insured. Any questions at all?
Yes, sir. I was trying to find out how can I pay a fine to get my license back?
Well, do you know where the fines are owing to?
No, sir. I was told that I was not able to obtain my license until I come to court for this matter.
That's driving this charge, second degree, involves driving allegedly during a period of suspension. If there's a problem with the fines, that would be a little different issue than here, but yes, you may still, if you've gone past the period of suspension, you still may have to pay off a fine, but I don't know where that is. We may be able to find that out. You did have an MTA on this case, which will go away, and that'll free up your ability to relicense.
Okay.
Given if looks like there's a warrant was issued, that's quashed as well.
Okay, thank you, sir.
And I think
We need to sign right here on this paper.
it looks like when we clear your FTA from today, that will free up your ability to relicense. But that is something you need to stay in touch with Mr. Haverco about.
Yes, sir.
Mr. Turner, the pretrial will be on March 31st at 11 o'clock in the morning. And I might indicate to you that the most important thing to me and to all of us is that get relicensed.
Yes, sir.
Get relicensed. That's.
Yes, sir.
No. We'll be giving the information. We're actually going to Josh Smeagol. He's the other guy. So before you leave the building, check in with the window, make sure that your Josh is in condition. But basically, we'll probably get this charge reduced. So this case. So just do your best with this, but then get a lot.
And Mr. Turner, don't forget to get a copy of today's order out of the door and to your left. You take care of yourself, and we'll see you here at the end of the month.
Thank you.
Thank you, sir. Is Jamie Zenner in the courtroom? Zenner, have a seat if you would next to Mr. Abercrombie. Good afternoon. Is your name Jamie Sue Zenner? Ms. Zenner, the citation I have alleges that on or about February 22nd, 2022, you committed the offenses of criminal trespass first degree and theft third degree. Both those charges are what they call gross misdemeanors. The maximum penalty on conviction for each would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter not guilty pleas to both counts.
Is there a plea of not guilty has been entered on your behalf? Again, that preserves your rights. Pretrial will be on March 31st, 2022. And as soon as everybody has signed today's order, you'll be able to get a copy of it by going to the window out the door to your left.
And don't go yet. Well, could you write your phone number down here? Oh, 306-22. 1306. No, 253-306. Okay, gotcha. Great. Thank you. Yeah, you're good. Yeah.
That, I've gone through the entire calendar, but we still have people in the courtroom. By any chance, Miranda Eschenbrenner show up? Ms. Baum, good afternoon. I'm sorry, I didn't see you sitting there. Yes, we have the interpreter on Zoom, not in person, but we have an interpreter. Come on up and have a seat. And again, I apologize. And the language is Polish. Ms. Colson, I see you're on the line and you're muted. If you'd unmute yourself, I'll swear you in. I'm so used to Zoom that I never expected you in person.
I know.
Hello.
Ms. Colson, good afternoon. If you'd raise your right hand. You solemnly swear that you will accurately translate from Polish to English and from English to Polish all that is said here.
Yes, I do.
Hey, thank you. Is your full name Tomasz, and I don't know how to pronounce your last name, Gaz?
Gotcha.
Czy pana pełne nazwisko jest Tomasz Goch?
Tak.
Yes.
regard to the citation I have alleges that on or about February 12, 2022, you committed the offense of driving while under the influence.
Około 12 lutego miał pan 2 przekroczenia.
That's a gross misdemeanor. The maximum penalty, 364 days in jail and or a $5,000 fine.
Kara za te przekroczenia jest 60 dni w więzieniu i 5,000 kary.
I'm going to ask your attorney to enter a plea on your behalf at this time.
Teraz zapytam pana adwokata, czy przyznaje się pan do winy, czy nie.
And Your Honor, we wish to enter a plea of not guilty. And we stipulate probable cause for the purposes of today's hearing.
The interpreter did not hear that.
We wish to enter a plea of not guilty.
We do not plead guilty. Not guilty. Plead not guilty.
And we wish to waive any formal reading.
The voice is muffled and the interpreter is not hearing it.
We wish to waive any formal reading and we wish to enter a plea of not guilty.
Rezygnujemy z formalnego przeczytania zarzutów i nie przyznajemy się do winy.
Okay.
Okay.
We will set the matter for a pretrial.
Przygotujemy się do rozprawy, do postępowania przygotowawczego.
Okay, I understand. What's a good time? There'll have to be an afternoon hearing due to interpreter availability.
Your Honor, everybody is masked and the voice is muffled and the interpreter is not hearing very well.
Okay, we'll try to do a little bit better. Right now, we're just trying to figure out when the next court date should be, and we don't need an interpreter for that until we decide what that is.
Thank you so much.
April 17th. We can't do the 14th. I can do the 28th. I can do the 28th. I'll make that work. 1 o'clock.
So we're going to set your pretrial for April 28th at 1 o'clock in the afternoon.
Postępowanie przygotowawcze będzie 28 kwietnia o 1:00 po południu.
Conditions of release are don't drive unless licensed.
W tym czasie nie może pan prowadzić, jeżeli pan nie ma licencji na prowadzenie prawa jazdy.
Do not drink and drive at all.
Nie może pan pić alkoholu i prowadzić samochodu w ogóle.
Does the city ask for any further conditions?
No, Your Honor, not at this time.
A plea not committed is entered on your behalf with regard to the infractions. We will calendar those along with the criminal charge.
Nie może pan mieć żadnych przekroczeń, żadnych kryminalnych przekroczeń, bo to dołoży się do tych zarzutów, które pan posiada.
Do you have any questions?
Czy ma pan pytania?
Nie mam.
No, I don't.
That concludes the hearing. Mr. Gotch, you'll be able to get a copy of today's order by going to the window outside the courtroom and to your left. Your attorney likewise will get a copy of today's order.
Zakończone jest przesłuchanie dzisiejsze. Zwróci się pan do okienka, gdzie otrzyma pan wszystkie pisma dotyczące tego przesłuchania dzisiejszego.
Okay, rozumiem. That concludes today's hearing. We'll see you on April 28th.
To jest koniec przesłuchania. Do zobaczenia 28 kwietnia.
Okay, do zobaczenia.
Okay, thank you. I will see you, Your Honor.
Your Honor, and I have
Ms. Colson, thank you very much. You take care of yourself and we'll see you or talk to you or rather on the 28th.
Thank you, Your Honor. Thank you.
Thanks so much for your help.
You're more than welcome. May I leave?
Right, and yes, you do have a Mr. Longozo on for
Right,
a.
Your Honor, I think there was some confusion with her. She's on her way here, but I didn't bring any paperwork. I thought the prosecutor was gonna be here because of the interpreter, so it's my mistake. I would ask that we set this matter over.
Certainly. Can we reset it to the same?
If that's okay with the prosecutor.
Yeah, that's fine.
That's fine with Mr. Dilly?
Okay, and then
Yep.
I'll call her off, okay? 'Cause she's on her way.
Okay, if she should happen to show up, I'll tell her to give you a call.
Thank you.
And we'll need an order on that, resetting. I keep forgetting to hit the refresh button.
Thank you, Your Honor. Have a nice day.
You two
You too,
take
Brad.
care. Hey, and again,
Thank you.
I was expecting you here instead of there. It's fine.
It's all good.
I'll do better next time.
It's all good, Your Honor. Thank you.
But drive carefully on your way back to Tacoma and
I will.
then signing the order resetting Ms. Longozo to the same date, and there's nobody left in the courtroom. I have a no show or two to deal with, but that is pretty much that.
All right. Well, we'll see you in a couple weeks.
Okay, Brett, you take care. See you then.
You too. Take care.
Ordinarily, I would review files to determine probable cause prior to issuing warrants. However, with the case of each and every individual that did not appear today, I had released them from jail and at that time found probable cause for the issuance of the citation. So we'll simply go through the no-shows. First one would be Miranda Aschenbrenner, docket 2, page 2. 2,500, cash or bond. Next would be Jeremy Brissett, docket number 3, 2,500, cash or bond. Next one I have would be Antonio Herbert Ray. It looks like we've already have the warrant out for him. Leave warrant. And then Timothy Thorne. 2,500, cash or bond. For each case. And that, as they say, until 2:30 is that is that. 20. Good afternoon. We're going to call the 2:30 civil infraction calendar. Present, I believe, is Antonio Ipez Suarez. If you're there, Mr. Ipez, you're muted. But we'll take your case now. If you'll unmute yourself and let me know if you can hear me or not. Good afternoon.
I can hear you.
Hey, perfect. You were cited for a no valid operator's license with ID a while back. You just will contest the hearing, is that correct? A contested hearing means you deny that you committed the infraction. Those are the choices. Either contest the hearing or ask for a mitigation. That means a reduction in the amount of the fine. Those are the choices, basically.
Okay. Can I ask for a reduction?
Pardon? Yes, you can.
Can I ask for
a reduction? Do you have a license now? Are you working on it?
I did I only have an appointment right now because there's not I only have an appointment on the I think on the 16th to do my writing test because I failed my writing test. I got 30 wrong and then 10 right. No, 10 right and 30 wrong.
Oh no. Well, how about that? Why don't I'll reduce the ticket from 553 is way too much. How about I reduce it to 150? And can you pay that at 25 a month?
Yes.
We'll do that. We do have a address here on Thuja Avenue. We'll send you a copy of today's order. It'll have that in there. Give us a call if there's any question or you have trouble making a payment, okay?
Okay, thank you.
Mr. Veza, good luck in getting licensed. That'll be a fine thing when you have that in your wallet. You take
All right. Well, when is the first payment due?
the Yelm Municipal Court. You can either mail them in. The address will be on the order, or you can come in person and pay it at the clerk's window. Public safety building where the police station is, next to the water tower.
Okay.
Mr. Ibez, good luck to you. Thank you for appearing, and you have a good day.
You too, Honor.
I will. Take care.
Bye.
So the matter of Yelm versus Roman Bashko. Mr. Bashko, you're it looks like you just unmuted. Are you able to hear me?
Yes.
Good afternoon.
Good afternoon.
You asked for it looks like a contested hearing on you got cited for 1, no insurance, and 2, expired resident registration.
Yes.
Contested hearing, that means you deny that you committed the infractions and you want to have a hearing on that. Is that what you wanted to do?
Yeah.
Okay, what happens is I'll read the officer's report, and then I'll hear from you. Burden is on the city to prove by a preponderance of the evidence that the infraction was committed. Here's what the officer writes. I'm reading from his report. On the listed date and time, I was conducting a routine area patrol of the Walmart parking lot. During this time, I observed the described vehicle parked in the fire lane, blocking a fire hydrant. A records check of the vehicle's plate showed through DOL, Department of Licensing, showed the vehicle's registration had expired in 2019, although the plate was displaying a 2022 tag. As I continued with my area patrol, I observed the vehicle leaving Walmart southbound on SR 507. I caught up with the vehicle and initiated a traffic stop. I contacted the driver who identified himself verbally. The driver stated he found the 2022 tab on another plate and switched it out. A records check through Department of Licensing confirmed the driver's identity. I issued the driver a sector infraction for expired tabs and no insurance, a copy given at the scene. That's what the officer says, that he wrote you for not having either, or displaying to him either insurance or, and that you didn't have a valid tabs. I'll listen to what you have to say.
I got my vehicle, my mom's vehicle. We got it registered, and that was my mom's car. I was just driving it that day, and the insurance. We got it registered now. On the date was January 12th, so it's registered now, and I'm not working right now, so I was wondering, is there any way we can get it is there any way we could do if we could somehow if we could drop the registration, because I got it registered now, and then the insurance, the we're getting insurance for it now, but I'm not working right now at the moment, so I was gonna see if we could
What I can do is reduce the amount of the ticket. This is the 553 is way too high for insurance. I'd rather have you get insurance. I'm going to reduce that to 150, and the expired registration, that's 231. I'm going to reduce that to 100. Now, what we'll do is we'll send you a copy of today's order, and you can pay that over time at $25 a month. Okay.
Okay, yeah, that sounds good. Thank you very much.
Okay, Mr. Bosco, thank you, and you take care. Have a good day.
You too. Thank you. Bye-bye.
You have a good day. Goodbye. And I forgot. Once again, I'm stuck in, I can't close Mr. Epez, and I forget what I have to do is close something else. Yes, save, close, continue.
Yeah, I would just, you know that you already, but then it doesn't.
It doesn't happen.
Okay, so then now. Now try to close it. Yeah, I don't know why, but when you say that it's not registered.
There goes now. I'll do the other one. I didn't have